President ICC International Court of Arbitration, Ms. Claudia Solomon, a gifted personality committed with passion to arbitration for decades. Her presidentship is a milestone achievement. Mr. Alexander G. Fesas, Secretary General ICC International Court of Arbitration, we heard him. He unfolded his thoughts. Mr. Tejas Chauhan, Director South Asia, ICC Arbitration and ADR. I must recognize presence of very distinguished professionals like Ms. Pinky Anand. She has contributed to the system enormously. I would be failing if I start naming people who are present here, including professionals who have impacted the system enormously. I must recognize presence of Mr. Rajit Punhami. He is Secretary Rajya Sabha. His presence would mean a lot, as we will be in a position to take forward certain things on which I would be reflecting. A disappointment to those who are waiting in the wings with my disclaimer. I have been associated with International Court of Arbitration, also ICC Commission on Arbitration. And all that I say may not be construed as supporting an institution as compared to other institutions that are holding the field. But surely I'm not doing that also. This inaugural session of 6th Annual ICC India Arbitration Day is coming at a very opportune time. We are in our Amrit Kal. India, home to 1/6 of humanity, is witnessing phenomenal economic rise, already having overtaken the economies of the UK and France. We are positioned as the 5th largest global economy. By turn of this decade, our Bharat would have overtaken the economies of Germany and Japan to be the 3rd largest global economy. That means enough work for those who are in this room, and we need to have a very robust mechanism. Celebration of centenary of ICC India Court is a very glorifying moment. I recall my days both in the commission and in the court. It was learning every time I went there. Getting in touch with people like Professor Tertier, who like ma'am was president of the court. A distinguished arbitrator, Professor Lavnes Bu, Hwang Ho, to name only few. So this is a platform much beyond the normal arbitral process you see. Some of the greatest minds on the globe scratch their brains, get together to make contribution to the spine of arbitral process. The journey of the institution has been really great. I was right, the throat is really bad. I would like to extend a very warm welcome to Ms. Claudia Solomon. We have seen rise of women, and that rise globally has been very, very stressful and difficult. Her election marks a momentous occasion as she becomes the first woman to hold this prestigious position. But it is climaxed by another significant event in the centennial year of the ICC International Court of Arbitration. With her extensive experience as an arbitrator and also as an emergency arbitrator, because this particular field will be occupying more space in times to come. She joins the ranks of trailblazing women who have broken barriers in the legal system. We lost just a week back, or less than that, Justice Sandra Day O'Connor, the first woman Supreme Court judge of the United States, they call associate judge. Only the Chief Justice is called Chief Justice. And that took place when the court was 190-year-old. We lost recently one of our very distinguished judges, the first woman judge of the Indian Supreme Court, Fatima Bibi. It took us less than 40 years. You are somewhere in the middle. For me, this is a great personal opportunity to share my thoughts with the people who matter in this country. Presence of everyone here is very impactful. But presence of some who are dominating the arbitral process in this country, who are occupying major space as arbitrators, their absence is equally impactful. This event is a powerful testament to the growing importance of arbitration in India, and this is indispensable if growth has to be on incremental trajectory. We are having explosive economic growth. India's economy is rising as never before. World entities have held out us as a favorite destination of opportunity and investment. The kind of progress we have recorded and the rate at which we are going has amazed the world. There are bound to be disputes. Disputes are natural to commercial activity. They happen because people have different perception about a particular point of view. We therefore are in dire need of having a system that is robust, fast, scientific, effective, and delivers with best of human brains. In this process, I greatly commend the step taken by the ICC for first session titled Recent Trends in Indian Arbitration Leaning Towards Harmony or Disorder. Nothing could be more timely. Nothing could be more appropriate. Nothing could be more to put us in reflective zone. We have to think within. The subject itself offers answer the moment we go deep into it. I am sure discussions and deliberations will take us a long way. Friends, I am sharing my thoughts. Nowhere on the planet, in no other country, in no other system, there is such tight fist grip on the arbitral system by retired judges. In our country, this is writ large. And I am in the sound company of a distinguished jurist, a great legal luminary, a brilliant mind who is changing the landscape of judiciary in this country. I am referring to Chief Justice of India, Chandrachud. He reflected on this. He reflected on the lack of diversity in appointing arbitrators. And what he said next is a very powerful statement. Only he could make it. His deep commitment to cleanse the system, to make the system robust, very functional, he could speak out. It takes a lot of courage to speak out so objectively about a fraternity to which you belong. And he said, retired judges dominate the field. Retired judges dominate the field. He goes on to add, and I salute him for this. He says, while other qualified candidates are overlooked, he implied that this reflects an old boys club mentality within the arbitration space. He elaborated on this by urging the retired judges dominate arbitral appointments, and in the process, several promising candidates are overlooked. I pause here for a moment. India is known for its rich human resource. In every domain, in every walk of life, we have people who can take a look at it. But they are not picked up to adjudicate arbitral process. Time has come when we need to introspect move forward by bringing about necessary changes, including, if required, by legislation. But I cannot but applaud the bold statement, timely statement, a statement that will go a long way in making arbitral process in this country spinally strong. The statement by Chief Justice of India, Chandrachud. Friends, institutional arbitration as compared to ad hoc has many advantages. I've been exposed to that while being in the court. It affords you a mechanism where things are taken care by brilliant mechanism and best of brains in the world. And that is why ICC arbitration is a brand unrivaled. It has stood test of time. However, judicial interventions in this country and elsewhere have reduced arbitration just as a tear in the normal litigation process. If you analyze arbitral decision-making process, it starts with rendering of an award. And by the time you reach making of the award, there is enough scope for judicial interventions. Brilliant minds, some of them are present here, know how to exploit judicial system to get interventions, and they are legitimized by law. So nothing wrong in that. You have an award, and there's a challenge by way of objections. A statutory appeal is provided. If you are a state actor, a public sector undertaking, you are well advised to knock the doors of the highest court, because till that is done, you will not be performing your duty well. So we have to evolve a mechanism where arbitral process does not suffer judicial interventions. I am not aware at the moment what the ICC International Court of Arbitration is doing. But while I was there, they had a unique mechanism of amicable dispute resolution. And that was amazing, that you do not render a judicially enforceable package, which you normally do when you take recourse to arbitral process. But amicable means it is in-house. Brilliant minds who have domain expertise are selected, and they help parties come to a consensual approach. I think time has come when we need to focus more on it. I know when disputes last long, a fraternity to which I belonged at one point of time gains invariably. But our fiscal gain cannot be at the cost of national gain, national prosperity. The world economic order will get up, go to greater heights. There will be evenly spread out progress for everyone if dispute resolution mechanism is fair, equitable, and conclusive. Most contractual stipulations provide arbitration award will be final. But then, in certain legal regimes, ours being the robust one, access to judicial system is a fundamental right. And no contract can have a provision that antidotes it or neutralizes it. So, access to the judicial system in respect of arbitral process or final outcome of arbitration is inescapable. This can be contained only when we go to amicable dispute resolution. I'm sure we must work out a mechanism that will help everyone, including economy and the people involved therein. We are living in very tough times. Even before the technological invasion has taken place in full bloom, we are alarmed, we are worried. Disruptive technologies, we like it or not, are part of our life. We are their bedfellows. We'll have to continue to live with them. And disruptive technologies bring in their wake disputes that would require instant resolution. We have one amongst us, the President of ICC India Court of Arbitration, acting as emergency arbitrator. Earlier, decades ago, we used to know only about interventions, interim orders that used to be very fast. But now we have to be faster than the fastest. I don't know whether it is right or wrong, but I read somewhere that someone asked Eisenhower, what is the speed of light? And he reflected, went today, came back yesterday. That kind of speed we'll have to show. Friends, what the Chief Justice of India reflected, one way out will be, we must have arbitral institutions. There has been some growth in our country of arbitral institutions, but those institutions need to take central space. And necessary changes in law are required to be effected to make them more meaningful. This will cleanse the system of something which we don't regard as very wholesome. Because this cannot be a pastime. It has to be a deep professional commitment. You have to be very passionate about arbitral process. The arbitral bar has to be evolved as a standalone, not as a collateral of the main bar. It is a very expert subject. And your contribution in giving cutting edge to growth of economy in our country and in the globe is pivotal. I am sure your deliberations will be extremely useful to come to that level. I do not wish to say more on the subject, given the position that I was associated with International Court of Arbitration and its commission at one point of time, and the position that I hold, both as Vice President of the country and Chairman Rajya Sabha. But I will leave a thought with you. Your session 1 is very critical to the economy of this country. Your session 1 must not be just scratching the surface. You will have to delve deep into it. There will have to be incisive analysis. The diagnosis has to be superb and super, like an MRI, not like an X-ray. That formulation I'm waiting for, and I'm sure we'll do something, since head of our judiciary has already made reflections about it. I conclude by saying that nothing can be more amusing that the highest court of the land will reflect in more than 36 pages, go to each and every detail of the arbitral award, and then indicate the courts must not probe in detail the arbitral award. Thank you.